Sixland can get a new identity, but guess what? Sixland has its name tattooed on its first. So it is also another challenges. Okay, it's a job, I know, but it's also a serious job because it's really happening in real time. So this session, you can see how important it is. So thanks to Freedom House for organizing this together with TIAC, which is doing a marvelous work. And yes, this is a form of ADI, very, very important at this particular time and place. And thanks all of you for attending, and I'm looking forward to a very vibrant discussion because I look around and I see like, oh, these are the heads that can discuss. And I hope people online also can follow up and also maybe make some other suggestions and put them forward for Gura and the Freedom House Lema, who can also recommend. There could be some very good messages for people who are not here. So thanks everybody, and looking forward to have a good discussion with you. Very good presentation.
So without wasting any more time, thank you for the wonderful remarks by the Vice President. Presentations. Very good.
Morning to the USID Tanzania or USG government in Tanzania, and implemented by Freedom House and part Tanzania. So we received a call from TIAC that we should support this dialogue, and we were pleased to support it because as a project what we are doing actually supporting among others, the legislative reform activities in the country. And we saw this as an opportunity for us to actually engage in the process of discussing and seeing how can the practice as well as the legal reform that regulate the food again in Tanzania can be actually reformed. I don't have so much to say, but what we want to say is that, as we say, as a project, we will be more than happy to actually engage and continue supporting this kind of activities and working hand in hand with TLS. We've been working with TLS for a long time now, and we continue working with TLS and TIAC now, what we call maybe what the PH of TLS, making sure that again we have proper and really well-informed sort of regulatory reform in Tanzania that helps the citizens. And in the end, we will not have Dr. Tenga saying he was a victim, but rather saying he was actually a beneficiary of this kind of initiatives and processes in the country. So thank you so much. We are happy to be here with you. We have the colleagues who are online as well. We invited other colleagues from embassies who are online from the US government participating. Will introduce themselves in the chat when the form is prescribed for them to introduce themselves. But all others have joined from other embassies will also be here. Thank you so much.
I think in the interest of time, we move to the first paper, presented by Dr. Tenga. Nafikiri wengi wetu hapa ni wanafunzi wake. Labda kwa wale ambao ni junior sana, lakini wengi ni wanafunzi wake. Miaka 30-40 anakwenda anafundisha. Karibu Dr. Tenga. Asante. Kwa huru, you have the
vitu viwili muda wangu ni muda gani? So they've changed it.
You have half an hour.
We lecturers to clear that because you are tuned to speak for 1 hour. Whenever we open our mouths, we lecture for 1 hour. That's standard time. Universities also the 1 hour. But we are regulated by time zone. Kingine cha pili ni kwamba tunafikia sana na mimi nazungumzia kwa beneficiaries depending on what you decide today. Hiyo vile vile inaleta problem kwenye objectivity. The person needs to be objective wakati wa kufanya analysis. So you have to distance yourself from the involvement and from the emotions also, which is hard. So the dialogue is good in the sense that others can also evaluate beyond emotion and involvement. A lot of our students, whenever we give them research papers and topics, they quickly move to their home area and so on, and develop subjects like that to discard. Because then your proximity to your loved ones and so on might taint your intellectual accuracy. So you'll forgive me if I slide that now and then. In choosing a topic, I had a little bit of a problem because I thought that a topic like that will come at the conclusion rather than at the beginning. So I read a little bit on how I'm moving to that. So the slides which I'm going to show you in the next 30 minutes are basically my attempt to invite you to a discussion. So that we can look into that. I'm working on much more detailed paper. So references in this are not as clear as they should be when I complete the written document. Now I begin with a quote. That quote simply says, what is the essence of liberty? What does it mean in criminal justice? It seems to be a new subject. So why a new subject at this moment? Why should we have a new subject called liberty? Is it old? Has it never been there? And within our criminal jurisprudence, based on we call adjudication, and focused on the adversarial system. When you introduce plea bargaining, what does that mean to the jurisprudence of adjudication of criminal justice as we know it? So the quote goes, plea bargaining is perhaps the most controversial method by which we resolve cases in court. Very controversial. And this was the outer rights in 1986 when it was being introduced in the US vigorously as a formal system. It was there from the 1920s, but vigorously in the 80s. Even the name invokes negative images, in as much as the system is viewed as bargaining with criminals. The moment we talk about bargaining with criminals, NPS are questioned. Why are you bargaining with criminals? The law is there. They are bargaining with criminals. How come? The home word. So now, moreover, finding a proper title is a task in itself. No name seems totally fitting. Currently, the most popular names are plea bargaining and plea negotiation. I think plea negotiation will be more fit for Gora. Gora wants to show the link between arbitration, negotiation, reconciliation, and plea bargaining. Neither term captures the extreme cases that are frequently present. The routine deal, we can't come up routine too. NPS, when I produce a document on assembly, to agree, what on a push. The defense disagrees on the circumstances of the victim. Often people don't look at the circumstances of the victim. And the coerced bargainings, it can be coerced, it can come coercion. And in certain cases, it looks like coerced bargaining. It's the easy way out. Have you really looked into the issue? Have you really looked into this problem? Or you want a quick fix? Right? So there are those contending observations about plea bargaining. The author was writing in 1986 a historical sketch for plea bargaining, Justice Portal. Black's Law Dictionary may define, that is our standard reference, a negotiated agreement. Plea bargaining is a negotiated agreement between a prosecutor and a criminal defendant, whereby the defendant pleads guilty to a lesser offense. Kwa hiyo kuna negotiation ya charges. tunaweza negotiate on charges, or one or multiple charges in exchange for some concession by the prosecutor. Usually a more lenient sentence, so the sentence bargaining, or a dismissal of other charges. Also termed as plea agreement, negotiated plea, sentence bargaining. Those are the various names of these phenomena. Now, Section 2 of our Act, Criminal Procedure Act, Cap 20, also goes that way. You see, plea bargaining means a negotiation in a criminal case between the prosecutor and the accused, whereby the accused agrees to A, plead guilty to a particular offense. When you have now negotiation due here, charge, you plead guilty to her. So there's a charge again. B, cooperate with the prosecutor in the provision of information that may lead to discovery of other information relating to the offense, the snitch scenario, right? So you agree to snitch, you get a favor, you're out. Are you protected? Our Vice President has said, there could be an issue. As kwenye haya magangs na nini, wewe umekuwa snitch, wewe utarudi kwenu Hedaro kule ukae, wakuangalia. Okay? So what to do about it? Or, anasema alternative nyingine, or the count charge in return for concession from the prosecutor, which may lead to a lenient sentence or withdrawal of other counts. Lenient sentence, unakwenda kwenye sentence bargaining. So there's an aspect about charge bargaining or sentence bargaining. If that is the definition, what is the origin? What's the origin of this business of negotiating with criminals? Some say it's religious. What want to play bargain from time immemorial. Actually from Mumbai, from place. Offense ya kwanza ilifanyika kati ya brothers wawili, Cain na Abel. Wote tulijua. Bwana Cain alipokamatwa sasa ameua. Akakubali kwamba Mungu akaamua kumbanish. Akabadili. Akamwambia Mungu, hii si punishment kubwa mno hii. Watu wakiliona wataniua. Which was a very strange statement. Watu walikuwa walimu kienda mama yake. He somehow walielewa. Akamwambia sasa I'll protect you. Kwa sababu nimekubali nishtuka mimi sikuua, I'll protect you. Akampa the mother of Cain. Kumwambia kwamba mtu yote atakayekuona kwamba hawezi kuua. So unaona kulikuwa na sentence bargaining between God and Cain. So kuna watu wanataka kwamba hii ipo kuanzia uumbaji. Watu wana bargaining, this is not very strange. Lakini anasema no, tribal societies. In tribal societies kuna bargaining. Hata kwenye offenses. Mtoka huko kafanya nini kwa bargaining, leteni ng'ombe kwa fulani, fanyeni hivi, fanyeni. Hata kwenye misahafu ya mambo yapo, watu walikuwa na bargaining, wafanya crime fulani. Kwa kuna binti yake sio kwa inaitwa Dina huko. Wale walio kwenye mabia wanajua. Tabaka si na watu gani, wale watu wakaambiwa. Basi mnaweza kumuuma huyu binti yetu, lakini mtahiri. Walikuwa hawatahiri wale. Lakini wale vijana wa Yakobo walikuwa waungu, walipoambiwa atahiri, wanaume wao wote wakatahiri, wakaenda wakawataka. Wakati wametahiri, hawezi hata kutembea, wakaungu. Yakobo ilikuja walaani. There are a lot of stories like that, like in tribal forms, una reports like the Max Gluckman, like in a Gulliver, tunakumbuka Kadume's case, wote tumeisoma Kadume's case. Kuna ingine drumming the scandals among the chief, tunakwenda watu wanaseke. Kwa hiyo ni njia ya mediation ambayo ni from tribal society. Ingine nasema common law. Yule author aliyemreport mara ya kwanza anasuggest kwamba common law courts they've always bargained. Cases will go bargain. Office prosecutors, always they've bargained. It was informal, it wasn't formal, lakini walikuwa na bargain. Wakibagain, mtu ataweza kuwekwa lesser charge, prosecution inaweza kuangalia labda ushahidi hauendi sana, kwa hiyo ngoja tubagain apate lesser charge yaishi. Ya mwisho kabisa hapa Tanzania kwetu, Justice Utamwa ameandika PhD thesis University of Dar es Salaam in 2020. Anasema investigation for promoting fair criminal trials in Tanzania. PhD ya 2020 September Utamwa. Amefanya kazi nzuri sana kwenye mambo ya plea na pre-trial procedures nyingi tu na ameziangalia kwa undani. One of the things ambayo nilikuwa na note ni kwamba much as constitution inapasua kwa kuwa na fair trial, speedy trials and so on and so forth. Huko katikati vile vile kumekuwa na system kidogo kama hii. Hiki tu sio strange, sio kitu cha juice. Hasa kwenye those serious charges. Mara nyingi kumekuwa na process hapa. Kwenye maana inafanya lesser offense, nini kwa manslaughter, so and so and so forth. Kwa hiyo sio kwamba haijakuwepo, lakini jaji watatuambia, watu wa MPS watatuambia, probably hiki tulikuwa kwa muda mrefu, lakini hakijawa visual as we see it today au formalized. Now, inakujaje ikawa formal sasa? Utaona in East Africa movement nzima ya kufanya kitu iwe formal ilianza in 2014-15. In fact, ya ajabu sana. Tanzania ndio walikuwa wa kwanza. Wa kwanza kabisa. Tanzania kwenye sheria nyingi ndio wa kwanza, labda baadaye sio na retract walikuwa wanajificha wakimbia wapi. Haieleweki vizuri. Lakini hata kwenye hili Tanzania walikuwa wa kwanza kabisa. Angalia Kenya, wana criminal procedure code cap 75. Walibadili section 137 ya kwao wakawa na clauses A to O. Nyingi ndefu A to O. Sasa sisi kama ukihesabu A to O ni clauses ngapi za kutosha. Lakini hao ni Wakenya wana clause basi na walikuwa wamekuwa vile vile na criminal procedure plea bargaining rules za 2018. Now notice that it's 2018. Na DPP wa Kenya, office of the DPP, wametoa plea bargaining guidelines ambazo ni very detailed on how to carry out plea bargaining by prosecutors in Kenya. Kwa hiyo wana system. Ukija Uganda, kuna Uganda Judicature Act. Imetoa guidance under that Judicature Act at 13 in Uganda. The Judicature plea bargaining rules of 2016. Notice the date, 2016. And then you come to Bongo. Bongo land ziko nchi mbili, si ndio? Mainland alafu huko kwetu huko mainland kuna written laws miscellaneous amendments number 2 act of 2014. Wali introduce plea bargaining. Wakaleka clause tatu ambazo zina amend section 194. Tatu tu. Lakini ile zile amendments ziletwa na Attorney General Werema. Somehow ile bill ikadisappear from baada ya kuuliza hapo kusema no, ilikwenda na kitu kinachohusika na bili nyingine. Si kwa na kuhusu kitu gani? Kabisa. Ilikuwa na kabisa. Kwenye uharaka wa kukimbiza kabisa kwa mtoto. Na plea bargaining nayo